Good evening, everybody, and welcome to another one of Simania Clinic's talks. Our topic for discussion today will look at the use of legal instruments to protect against GBV. Our speaker for tonight is Advocate Vilakazi. He is a mediator as well as an arbitrator. His key focus areas are in family law, customary law, as well as corporate law. He regularly gives of his time to pro bono services. His passions are in teaching communities about the law, and he has also been on various radio platforms where he has provided content and information around GBV. Thank you so much, Advocate Vilakazi, for being with us here tonight. Thank you. It's such an honor.
Thank you for having me as part of today's proceedings. I'm really honored to have been invited by you.
So we'd like to open up the discussion then, Council, with regards to GBV. What do you think is the best policies that we can use at the moment to protect against or to mitigate against GBV?
So, the way I see it, Dr. Kim, is currently within the country, there's a general lack of information and a lack of knowledge in respect of how people can lessen the impact of GBV, especially towards our women, etc. Oftentimes these matters get resolved by family meetings and family members, but the reality of it is violence, and sometimes it doesn't need to go towards a platform where there can be no repercussions for the perpetrator, because then it spirals out of control with time. So the way I see it, and in fact, this is quite important to the audience, is that when there's an incident of GBV, the first place to start is your local police station, where you must go and lay a complaint with the police. And whilst you are there, they will give you what's called a case number or a CAS number in order to say, well, your complaint is in the system and it's being processed. And then obviously with that comes an element of an investigation if need be. However, there is a challenge in regards to our police force. The first thing is that they're inundated with complaints. They also have the experience of complainants going back to the same offenders. So what our police officers then try to do is that they try and solve the issue. They look at the issue as a domestic issue between two partners, two spouses, two lovers, whatever the case is. So they then say, you know what, go home, go and sort it out. Let's go talk to him. Sometimes what they'll do is they'll also get the complainant into the van and take the complainant home and try and sort these things out without the paperwork that comes with it. However, there is a second option, and I think this is where I just want to focus on today. A lot of the times our people are not aware that within the magistrate courts that we have, there's a domestic violence office within it. And within this domestic violence office, there is also a family court that is attached to it. So in issues where there's domestic violence, sexual harassment, or issues revolving around children, divorces, our magistrates courts are quite capable, in fact, of handling such issues. Now, who then is going there? So the person that would go to this office is anyone that has been abused, or it's a minor who may also lodge an application unassisted, or it is a guardian of a minor. So it's not just the parents, mother, father, but it extends to the aunt, the grandparents, the uncle, the brother and the sisters. In fact, it can extend as far as people that are your neighbors, because, oftentimes it's neighbors that pick up that there is some sort of GBV. However, they do need the assistance of the complainant in that regard. Now, there's also other people that may apply with the written consent of the applicant to go on their behalf and do this complaint. You know, it's a counselor, a health worker, a police officer, a social worker, or even a teacher, because those people are also privy to the effects of domestic violence. You know, a lady is beaten up sadly, and the following day she shows up at work. And all of these people, because they have a vested interest in the life of the person involved, they may go forward, obviously with the written consent of the complainant, but topmost counselor, health worker, policeman, social worker, and a teacher. So then how then do you get to lay this complaint? Well, then the steps to follow, in effect, are that one has got to apply for a protection order at a magistrate's court nearest where you live and work at any time, during or outside of court hours, and court hours are from 9 until 4. But actually, you can apply outside of those hours, as well as on public holidays and weekends that would follow. Now, there's a two-stage or two-pronged process, if I can call it like that. What effectively you first apply for is an interim protection order by completing a form which is called a Form 6 at the court. Now, what the interim protection order seeks to do is it seeks to stop the violence in the interim, so in the meantime, whilst the perpetrator is advised of it, and he also has an opportunity to come forward and speak about or give his side of the story. And obviously, one of the big legal principles within our country is that the other side must always be heard. So even if there's a complaint, it doesn't mean that the other side cannot be heard. And therefore, the courts and the Department of Justice have devised the interim protection order as a means to stop the violence temporarily, at least, the violence temporarily, whilst the other side is also afforded an opportunity. Now, once that interim order then is done, then one can apply for a protection order, which is then a full and final application, as it were. Now, that application, how it's done is that it's done by way of affidavit, which states the facts on which the application is based. For example, my partner, Mr. X, regularly abuses me. It will also say the nature of the order applied for. I don't want him coming to my house, or I don't want him within 100 meters from me. You must also mention the name of the police station where the complainant is likely to report any breach of the protection order. So the nearest police station to me is Gugulethu Police Station. It is at NY1, corner of NY1 and NY108 Gugulethu. Remember in the beginning, I also said that an application can be brought on behalf of a complainant by another person. And if that happens, and it's the right thing to do, you know, the other person must also say why they are bringing this application on behalf of another person. So what interests do they have? Now, it could be a family member, it could be an extended family member who sees these things. It could be a teacher, it could be a police officer or a social worker. That person must also then say what occupation they are in and the capacity in which they bring such an application. There must also be the written consent of the complainant, except, of course,
can I come in there, Advocate Vilakazi? With regards to the interim order, so frequently once you've completed that application form, it gets evaluated by the magistrate, and the magistrate is the person who then decides whether you'll receive this interim protection. And it would be based on whatever annexures you've really provided to that application. So you may indeed be feeling threatened or that your life is in danger. But if you don't know how to present that information or to put it together or piece it together properly because you're not being assisted by an attorney or you're bringing the application on your own, there is a sense that your life then is in danger based on that fact because you haven't provided the annexures the way they should have been provided, or you haven't provided a founding affidavit. So, to the people out there who may listen to this talk, what advice when doing an application for a protection order would you say is crucial to add to that document to ensure that they are somehow protected?
Yes. All right. No, thank you for that. It's a very good question. There is a quote that says that a picture is worth 1,000 words. And people generally, we now live in a society where there's smartphones everywhere. Victims must always be aware. Oftentimes court like what we call corroborating evidence, or evidence that goes to prove the case that you're trying to make. And one of the things that one can do in that case, take pictures, present a story, record an argument. Also be aware that in the court itself, the court staff that will handle the issue are actually well-trained people. The third thing I would say is, and oftentimes we see this with domestic violence cases, the complainant has an element of fear about them. There's an element of shame about it. But the only way that women can advance and we as men can help them advance is if we drop the fear of being stigmatized by society. So the key is, if you've got corroborating evidence, if you've got neighbors, for example, that might have heard this violence ongoing, get them to come in as well, because that adds strength to the case that you're trying to make. And that is basically probably the best way to convince any court that one's life is in danger. So don't feel afraid to share the details as much as one can think of stigma. Life is ultimately more important than the shame of opening up a court case.
Then another quick question there, and I think key for the audience as well. WhatsApp messages and recordings, could this be submitted as evidence?
Yes, of course. Mm-hmm. Yes. So sorry to have cut you there. Yes, WhatsApp messages can form a basis for the complaint that you have. And therefore, by showing that to a presiding officer and the staff, you are literally building your case. Any recordings, remember those recordings later on will get tested, but the bottom line is you're very likely going to walk away with an interim protection order until such time as those recordings and WhatsApp messages are tested in the correct forum. But I want to say to the audience that the first port of call is, let's protect the life that we have. Therefore, let's show everything, which will help make the work of the magistrate much easier in that regard.
Thank you, Advocate.
So yes, as I was talking, I suppose the second part then it will be the fuller protection order. Obviously, once the other party has been heard, and I've already covered, in respect of how to do it, in respect of an affidavit, if it's done by a family member or another interested party, they also need to provide the affidavit, and you as the complainant must give them written consent to do that. Written consent can be done in a few ways. Go to the police station, or even in the court, in fact, itself, because there's always commissioners. Write out your written consent and hand it in. And if they want it stamped, that's fine. If there are children involved, if they are mentally retarded people, or the person is unconscious, those people, you can then make the application on their behalf. And then obviously that form will need to be certified with the clerk of the court and then be submitted. And then that then goes through the legal framework in the country. I think the other thing that I want to touch on as well, just for the audience, is South Africa is actually a very advanced democracy in comparison perhaps to our neighbors. We do have the Domestic Violence Act, which is as old as 1998. As well as the Sexual Harassment Act. Now, in respect of the Domestic Violence Act, it's there and it's used in emergencies, and such a service is available 24 hours a day. You may, because of you're using that act, you may get a protection order which may be obtained in the same day, but it normally depends on the complexity. In other words, what facts have you presented to the case, to the presiding officer? And then, of course, that order then is valid until the abused person cancels it. And most importantly, and I think it's quite important for people to know, the cost of our court officials together with social workers assisting in these matters is actually free. So that's the Domestic Violence Act. The other act which is related to this is the Sexual Harassment Act as well. And it normally actually just follows the same lines in respect of the Domestic Violence Act. And it's there to protect the interests. Now, harassment can come in many forms. It can be online, it can be physical, it can be mental, much as any other form of violence can be. So it's important for our audience to just go out and read about this. Now, Dr. Kim, perhaps the last one that I think I should touch on is sexual harassment in the workplace.
Okay, before we go to sexual harassment
Yes.
in the workplace, can I bring in Dr. Libeko and Tandiwe here? Dr. Libeko, from your end, have you ever met anyone that's needed a protection order or found an urgency to get one? And was that difficult for them to ascertain the information?
Unfortunately, Dr. Lamont, I have never really come across such a case.
Mm-hmm.
Yeah, so I don't really have a lot of coverage on matters of this nature.
Mm-hmm.
Yeah.
And then Tandiwe, from yourself, is there any light you'd like to shed from your perspective?
No, from a legal perspective, good evening, everybody. I do not really have anything to share from a legal perspective, Dr. Lamont. Sorry.
Okay, not a problem. I think for myself, counsel, there's a misconception that you can get a protection order from the police station. Many women go to the police station and people are looking for assistance. There's a belief that this protection order is issued at the police station. So if you could clarify that, I think it would be quite an important one as well for the audience. And then maybe just for women out there who are maybe stay-at-home moms, can we look at the economic effect or economic deprivation from a domestic violence perspective in terms of finances and whether you could actually bring a protection order against that?
Okay, no, thank you for that. I think it's important for us to put into perspective the work of the police. So our police officers are there to serve and protect the communities in which they are placed. So effectively, the work of a police officer is to stop a crime in progress, and it is also to arrest an offender in the event that they are committing a crime. However, when you're asking then for a protection order, it is against a fundamental precept of innocent until being proven guilty. And this is why our courts get involved, or the officers within the courts get involved as a first step to say, we are happy to entertain your complaint. What will generally work better for the office in the magistrate's court is if you were to come with the same complaint that you have given the police officers, to say, this was my complaint to the police officers, because that then adds weight. So it's the misconception that it is our police that can give a protection order is misplaced. Our police can stop you from being harmed physically at that time. But, and what our police officers can do is that if you then lay a charge of assault, they can then, depending on how they find the facts at that moment, because they do have the power to arrest, they may then arrest the offender. However, our courts, as I said, do need to get involved in this because it in a way offends some of the basic rights that people have. So that's the one question. The second question was in respect of the economic hardship that a woman may face, and whether that is enough for them to get a protection order, as it were. Unfortunately, how the Act currently sees it is that economic hardship is probably much more difficult to prove, as it were, and what then is rather easier to prove. It's a form of abuse that is happening to you or anyone that you know. Now, that abuse can take on a few ways, according to the Domestic Act. There is an element of economic harassment, for example, any form of abuse which includes physical, sexual, emotional, psychological, or economic harassment. There's also damage to property, stalking, entry into a person's property, for example, without their consent, or any other abusive or controlling behavior. But again, it comes down to something which is quite important. Economic harassment can be defined it can have many examples rather to it. If somebody is stopping you from going to earn a salary, that is a form of abuse, which is not just physical, emotional, psychological, but is also economic, because now generally the women that work have got families to feed, etc., and that's impacting quite a lot of people. So then, if there is that form of abuse which is economic, I would ask that it is important for the listeners to understand, go and bring the evidence before them. If you are missing days at work because your husband won't allow you to walk out of the house, and then again refuses to compensate you for what you could have rightfully earned yourself, try and find as much corroborating evidence in order to bring that forth, and then ask for a protection order in that manner.
Thank you, Counsel. Two more key questions, just linking them back to other talks that we've done. So for the lesbian and gay communities, if there is an element of partner violence, which act would protect them against that? Would it be Domestic Violence Act, or would it be the Harassment Act? So what do they apply for there? And then the second question, in instances where the parents are potentially divorced or are divorced, and the children actually stay predominantly with the primary caregiver, and the primary caregiver is being violent towards the children, could the other party then bring a protection order? And how would they get social services or social development involved to demonstrate that, in fact, this child is suffering some sort of abuse and it's an urgent matter that requires intervention?
Yeah. So let me answer the second question first. In instances where children are being harmed, our Constitution makes it very clear that in all cases involving a child, the child's best interests are paramount. So one of the things that every child has, including every other person, is right to bodily integrity. It's also right to a mental integrity, as it were. So in cases where a child is being harmed, you'll remember earlier on I said an interested person may come on board and make that application for the child. So let's make an example of something that we know happens in this country. Due to the prevalence of HIV and AIDS in this country, we have a lot of child-headed homes. And because those homes are headed by children, there is also a potential for abuse in that regard. So as an example, a neighbor, a family friend, an extended family member a teacher may go and open this case on behalf of the child, because the child is not yet legally equipped, as it were, to open cases. But of course, that doesn't stop the child from reporting it. However, it does make better sense if there's always then somebody who is of legal age and capacity in order to assist the child in that regard. So yes, at the end of the day, children are very important to this country and they are protected. The first question then, which related to the gay community, if I can call it that way, and the lesbian community. At the end of the day, gender-based violence is simply based on the fact that it is one gender that is perpetrating the form of violence against another. However, that gender does not always have to be the opposite gender in order to perpetrate violence. It can be people of the same gender, and it will still be classified as gender-based violence. And in this case, it can be two male partners, one is abusing the other. And in respect of the law, especially for people that live together, I take it as that the best option to use would be domestic violence, because that is in effect just cut out into the home environment or the living arrangement that these people have. Even in the event, of course, that they didn't live together, the law would still cover them under Domestic Violence Act, as well as Sexual Harassment Act, because even that is a form of harassment. So to put it in perspective, these two laws can work side by side, because sometimes a person they may have one crime committed against them that actually covers two laws, as it were. And so both can work in unison towards proving that point. So I suppose to round off the point, it doesn't matter what kind of relationship you're in. If there's a form of any sort of abuse, mental, psychological, physical, economic, or otherwise, these acts are there to protect the larger community or the complainant itself, I'd rather say.
Thank you so much, Counsel. If I can ask, are there any questions from the audience before we move on to workplace dynamics and GBV? Dr. Libeko?
Nothing from my side thus far. Thank you.
Okay, thank you so much. Counsel, you can proceed.
All right. The last one is just sexual harassment, and I see that our time may be against me, so I'm just going to pretty much go quickly through this. So one of the bigger problems that women face in the society is sexual harassment in the workplace. Pardon me. And the reality of sexual harassment in the workplace is that, you know, there's people that you walk into a company and there's people that have been there a long time. It may be tacitly being approved of in various manners. You know, there's the office clown who will pass off sexual remarks and people will, you know, brush it off. But the bottom line is it is actually harassment in the workplace, and it could be of a sexual manner as well. So it is as bad as domestic violence. As I said, it's condoned, but sexual harassment, generally what we find, it's probably by a superior over a junior, and it can also be what we call quid pro quo. So if you give me these sexual favors, I will then make sure, for example, that you get an increase. I will make sure that you get a better position. Yeah, and it can be virtual in the form of cyberbullying, and it can be extended or just one incident. Now, a lot of people think that when they get sexually harassed only once and then it goes quiet, that isn't a form of harassment, but actually it is. So it doesn't have to be many incidences for it to form sexual harassment. And lastly, what it really does in this case is that it stops the advancement of a person, especially women in our case. It stops the advancement by merit. Now, there are laws in the country, for example, item 4 of the code of the 1998 Code on Sexual Harassment. And it does spell out what sort of what sexual harassment is, and it's, you know, physical, verbal, nonverbal, and it then breaks it down as well. You know, what is physical conduct of a sexual nature? You know, unwanted physical contact. You know, touching to sexual assault and rape, strip search in the presence of the opposite sex. It can be verbal, unwelcomed innuendos. Hey, nice skirt. Hey, you know, your shirt is full. That is a form of sexual harassment. You know, terrible hints. You know, I think you and I should get together. And so the code is quite extensive, but it's not limited. That's the beauty. And it also, for example, the code does look at harassment over online and social media as well. So how then does one overcome this? Well, first things first, you should be reporting it to your employer. And one of the things that people forget to do when they report such things is to note them down. I always say that if you're going to do it, please make sure that you write it on an email and CC yourself on that email, but make sure that you have a copy of that email if you're going to be reporting harassment within the workplace. And if, of course, then the employer does nothing, then one has got other avenues. The most common one would be something like the CCMA or the council, which forms part of the bargaining council in which your line of work may fall into. For example, the police have got their own bargaining council and it's outside of the CCMA. So one would have to look at those things when they want to then take the complaint outside of the formal work structure, perhaps because no one is attending to it. But at the end of the day, the code is there and it's there to protect your interests. The worst thing that any, especially women, can do is to keep quiet about sexual harassment in the workplace or any sort of violence against them.
We have one question coming through, Council. Dr. Libeko, your hand is raised.
Yes, thank you very much, Advocate. Thank you very much, Dr. Lamont. So my question just is based on what you have just mentioned with regards to sexual harassment at work. So my question is, is there any form of protection of the victim from the perpetrator, more so if the perpetrator is a superior or a manager at work? In terms of, the repercussions of reporting the case might be, to jeopardize someone's work and all that.
Yeah. No, thank you for that, Dr. Libeko. And it's a very good question. The reality of the work environment in South Africa is that oftentimes, if people are in powerful positions, then a company is more than happy to lose the junior employee, as it were. However, one thing that I found in my experience is that mostly large companies, and I'm talking about ones that have got head offices everywhere, they might be multinational, they will oftentimes have a dedicated HR specialist whose work is to look, whose work is to process such complaints by victims and make sure that they're carried through to finality. The second one is most of these larger companies would have a whistleblower line. Now, the whistleblower line is mostly for economic sabotage or economic harm that is caused to the employer, but it does not stop people from using that very same line, which makes a victim anonymous in order to report a crime or a transgression against another employee. Lastly, perhaps on that point, is that it is trite in law that an employee should not keep quiet when they see the employer's interest being put at stake. And sexual harassment in the workplace, unfortunately, is one of those interests that the employer has, because the employer's duty is to provide a safe working environment. And therefore, employees can report it. Employees can sometimes choose to remain anonymous, but at some stage, the matter will need to be ventilated, perhaps in front of a disciplinary committee. And this is when people might have to come out. So people need to be just aware that one can't remain anonymous forever, especially if you've laid a complaint like that against a person who has a right to face their accuser.
Dr. Libeko, are you answered? Your hand is still raised, or do you have a follow-up question?
I've got a follow-up question, but the hand couldn't go down in any case.
Please proceed, not a problem.
Yes. So let me try and get my thought together. So in terms of, the whole reporting, sometimes, what we often get is, people are trying to process, whatever the incident is emotionally, and they take a bit of time, to emotionally try and be stable, and then they can report. What is the negative impact of, trying to, taking a bit of time before you report an incident, whether it's GBV or like based at home, or whether it's a workplace sexual harassment. What are the repercussions of such, but also how do we still protect the emotional well-being and the emotional space and the emotional capacity of the person to be able to report whatever the incident might be.
Thank you, Dr. Libeko.
Dr. Libeko, thank you for that.
Council,
just to answer Dr. Libeko's question, then, which I think is a very good question. It's a principle in our law that delaying in reporting an incident does not invalidate that incident, as it were. However, there are general timelines which are applicable. But in the case, so in such a case, as an example, a woman is treated inappropriately by a manager, but reports it only 6 months later. There is no reason why that complaint should not be entertained by the company. And one of the reasons why the law allows people to report at a later stage is because not everybody processes information in a rational or in the same manner as the next person would. And an example of that, an employee gets sexually harassed at work on the Monday. As she's going through this trauma on Monday afternoon, she gets into a car accident, she breaks a leg, now she needs to be home for 8 weeks. And now can only return to the workplace after 8 weeks, as it were, once she's healed, and then she reports it. So there is no prescription of time, as it were, in respect of that. There's actually quite a famous case which involved, I believe, Bob Hewitt, who was a tennis coach in South Africa. He got convicted for crimes that had actually happened in the 1980s. And I think he went to prison in the last year or 2 years, as it were. And another famous example would be Bill Cosby as an existence, because his crimes, were ranging from the 1970s onwards. So it goes to show that point that it doesn't matter how late you come. The best thing is for you to come there with sufficient evidence, as it were.
Thank you, Council. Tandiwe, anything from yourself or any add-ons there? You're still muted.
Kim, just to add, sorry, I was muted. I realized I was muted. I think to what advocate was saying, many people sort of don't know how to navigate, or not necessarily they don't know. It's not very easy to understand what is going on because normally, remember, sexual harassment, when it happens, most of us are not even aware of the law. We're not even aware of the rights that we have. And because of this, you still sort of have to think about it. Make sure that when you go to the law and try to report such a case, you have enough evidence and you have enough emotional strength to carry it forward. Because I think we cannot also not forget the fact that it's very emotional, because it affects your well-being, it affects your financial standing, it affects where you will go in life. So there's a lot of dynamics. So the most important thing for me would be to say that it is very important to do awareness and make sure that people who are likely to experience these things are aware of the timelines, they are aware of the rights that they have and the mechanisms that they can take in order for them to find assistance.
Thank you so much, Tandiwe. A question for myself, and maybe in there's also a comment, Council, is do you think that gender parity and underrepresentation in certain areas of work is one of the reasons why we're seeing harassment in the workplace, particularly towards women? If I bring it even closer to the legal spectrum, I read some shocking statistics today of all legal practitioners, only 40% are women, and of those 40%, only 20% are women of color. So is there also an element perhaps of prejudice with regards to how women are treated in the workplace?
Thanks, Dr. Kim. That's quite an interesting, that's a very good question. And in fact, I agree wholeheartedly. Remember that, or in fact, for the history students in life, they will know that as recently as the 1950s, 1960s, and probably half of the 1970s, many women were not actually working. Women have always been looked at as people that are caregivers, homemakers. And that in itself has led to massive underrepresentation of women in junior ranks, but also at executive level. And that is one of the reasons which then perpetuates sexual harassment against women. There's not enough women in our workplace. Many employers, through their own stereotypes, will probably choose a male over a lady. And I've heard of many reasons. No, this person, she might not be well for a week every month. And those are the stereotypes and misconceptions that are out there about women that then condition a person to move away from women and start hiring more males, which then leads to this gender disparity that you've spoken about in respect of women not being equally represented in the workplace. So 100% agreed with your sentiment.
I see Mpo's mic is off. Mpo, do you have a question? No, I don't think so as yet. You can, Dr. Lebeko has his hand raised. Proceed, Dr. Lebeko.
Yes. So just going back to gender-based violence, just a bit back. How complex is it to deal with spousal sexual harassment? Like when you have a partner, and how do you go about that, and how do you deal with that? How do we know, where to draw the lines, and how do you even report that?
Dr. Lebeko, thank you. That's a very good question. So there's a lot of misconception. A lot of people, and I've heard these comments, and I'm sure we would have had, you can't rape your own wife. No means yes, and various other shocking innuendos and comments that are given insofar as partners are concerned. The reality of it is no means no, number one. Secondly, consent is always needed, especially in cases of intimacy, especially and in cases where there is no consent. Prima facie, that proves that there was some sort of abuse against the person that didn't give consent. Now, it is probably tougher in a home environment to prove something like sexual harassment, but it's not impossible because the courts have grappled with such issues. And one has always got to be reminded of what the Constitution says. It says that a woman has got the right to bodily integrity and a right to decide what to do with her body. In the narrow sense, that is looked at as referring to pregnancy and termination of pregnancy, but we are always enjoined to interpret the Constitution in the widest sense possible. And that right also then covers the right to say no at times when people might want to get intimate, and that right is protected as well. It wouldn't be the first time that the courts have grappled with spouses or lovers coming to court with one saying that they have been raped because they did not give consent. So complex, yes, but absolutely not a tough hill to climb if one comes with a coherent story, but also most importantly, will present further evidence on it.
Yes, Dr. Lebeko, can I add on to your question quickly before we move from that that part. A very interesting one at the moment, Council, is that we can see the divorce ratings are actually going up at the moment with COVID-19. And in some of the divorces, one of the reasons for the divorce is lack of consortium, so lack of relations with your partner. So in the event that that is brought up, but you felt that there was elements of, can I say, harassment, or your partner actually forcing you, what would you have to provide to the court to demonstrate that? So do you need an affidavit, or what could you potentially use? It's quite a broad question, but I think it could be something that comes up in divorce matters particularly.
Thank you for that, Dr. Kim. So one of the rights in law to a married couple is exactly the issue of consortium that you spoke about. And consortium extends across a few varieties: the right to love and care, the right to be, fed, etc. And in fact, perhaps let me call it intimacy is also a right, as it were. However, our constitution does limit all rights except the right to life and the right to dignity. So just because you yourself, I feel that I have the right to intimacy with my wife, does not mean that she then loses her right to say no. In fact, her right to say no is actually higher than my right to intimacy as and when I want it. Now, in divorces, it's pretty interesting that you say that people are raising that issue as a reason for divorce. In fact, there's effectively two reasons for divorce in this country. One must be that the relationship can no longer be salvaged, and it must be gone. And then secondly, would be that one of the partners has abandoned the marital home. As things stand, in fact, our courts are moving away from the abandonment of a marital home. I was involved in a divorce where the couple was divorcing but still staying in the same house. However, the fact that they've lost the love and affection for each other is actually the biggest reason. Any reason on top of that simply becomes supplementary and is not treated in the same light as having lost love and affection for each other, and that the marriage is can no longer be salvaged, as it were.
Thank you very much, Advocate, for that. So to frame my question, I'm going to create a scenario. So I have got a wife and I've got a child. So my child grows up, and then there's incidences of sexual harassment. I abuse my child, and because I'm the breadwinner, then it becomes difficult for my wife to actually report me. How does she go about this whole thing where, maybe reporting me means that she's not gonna, be able to be supported, by me as the perpetrator? How does she go about doing, reporting that, and how is she protected from, that worst case scenario?
So, very good question, Dr. Lebeko. One of the challenges in this country, in fact, is exactly the scenario that you have painted. And it just it's not limited to the nuclear family, as it were, but it also spreads to the extended family. And that is a lot of keeping quiet, as it were, when there are instances of sexual harassment, things being swept under the carpet, such issues being resolved by way of family meetings. However, there are two competing rights in the example that you've given me. One is the right to dignity / right to bodily integrity, if I can call it that way. And then the other one is literally food on the table. So from where I sit, the fact that one may lose food on the table should not be an overriding factor as to the protection that should be afforded any family member, but most importantly, children. Now, a wife still does have the right to go and report her husband if he is involved in the abuse of a child. And In this case, the wife may also give evidence. There are certain instances in law where a wife cannot testify against her husband. However, in cases where there is a crime and this crime is against a minor, then the wife is allowed by law to testify, because there's a third party to this entire thing whose rights are also being prejudiced. So for women that are listening to this talk and will hear this talk, the fact that your husband provides is never a good enough reason for there to be abuse which is tolerated in the home, especially abuse that is aimed at children.
Thank you, Counsel. If I could follow up on that one as well. So if we look at the different mechanisms that one could use to protect that family, I would say the first thing is to involve social services. So you can report it at the police station. The police station has a certain sector that provides social services, and they'll request you to do an affidavit. Once that affidavit is done, you can then go to social development. Social development, they'll assign you with a social worker. The social worker will interact with yourself, and they will interact with the child and see and try to get a better understanding of what is actually going on. Following that, in terms of the fear of not having, or rather being financially deprived, you could also go the protection order route, because in fact, that's what we've discussed today, that financial deprivation as well as being physically affected requires you to get a protection order. So then you'd be able to get this person out of your house because you prohibit that via the court. Following up on that, you could then do even a maintenance order where you actually go and get your maintenance form. You fill that out. It's a very similar form to the protection orders. Usually they sit right next to each other in court. And you fill that out and you apply for maintenance. So there will be maybe a small or short period of time where you won't be having direct access to money. But once the form is done for maintenance, if it's an urgent matter, they will also provide you with an interim order that Mr. Vilakazi, our advocate today, has spoken about, and you'd be able to access money for your child through those mechanisms. So I think those are also tangible steps in addition to what our counsel has mentioned for a mother or any parent to take in the event that their child is being abused or affected.
Okay, thank you very much. Just so let's within that scenario, let's complicate the scenario a bit. So my daughter is a minor, and my wife does not believe what my daughter is saying, and it is actually true. What does my daughter do in the scenario where I'm actually abusing my daughter, but she's a minor?
Yeah. All right. So earlier on, I had spoken about, Dr. Lebeko had spoken about other people that may bring such an application on behalf of the minor. As an example, the wife doesn't believe it, and an aunt gets involved. Now, your daughter's aunt may actually bring this application on her behalf and say that, well, she's also faced with a challenge of having the very people who are in the house with the minor believing the minor. And that is a standard issue that does happen in this country, sadly, from time to time. Also, the involvement of social workers who can also depose to an affidavit in their professional capacity. It would also be probably advantageous for this minor to undergo some sort of evaluation, as it were, especially bodily evaluation by a registered, a qualified person in that respect, who will then be able to attest to the violence that is being visited upon this minor. So at the end of the day, the protection is not put in the hands of only people that are close to you. A school teacher can get involved in this thing because generally children have their favorite teachers who they can go and tell these things. And the school teacher can take it up on behalf of the minor, as it were.
I see Dr. Libeko is answered. He's got his thumbs up. Are there any other questions from the audience?
Dr. Kim, I would have a question, and it will touch on the few of the different laws that advocate has mentioned. So in a case where the woman is not staying with the father because of domestic violence issues, and in the after that the woman left, the guy was still verbally abusing this person. So I blocked the person. Okay, this is my story, advocate, and you can answer it as personally as you can. So I blocked the person from accessing my phone, and this means that I'm blocking him from seeing the child, of which obviously the Child Protection Act, I'm contravening the Child Protection Act, but at the same time I'm protecting myself from being accessed by somebody who's abusing me. So in that, he denies me the financial support that the child so deserves. What could you say about a scenario like that? In case the person, obviously, in case I get a summons to go to the court, how do you think my case would look like, and what should I be on the lookout for?
All right, Ms. Maritane, thank you for that question. So, in effect, all parents have a duty of support. It does not matter under what circumstances one may be deprived of. And this simply boils down to the fact that a child has got daily needs. Some of those needs can be covered by finances, such as food, for example, such as some form of schooling that the child needs, clothing, etc., etc. And some of those other needs are provided by close contact between parent and child. So a father, for example, in this case, is not allowed by law to withhold maintenance simply because he is not getting access to the child. The child still needs to live. The child still needs to live, as it were, and in that regard, the child has got all of these needs that need to be taken care of. And the father then cannot run away from the duty and the obligation to provide those needs. So a man who isn't seeing his child still has a duty to pay maintenance, whether he is in a good relationship or in a sour relationship with the mother of his child.
Thank you, advocate.
Quick one from my side, Council, and then we'll take the last round of remarks, and I think Dr. Libeko can summarize for us from there. In the event that we do have maintenance and you've been given the maintenance order and the person refuses to pay, what rights does the complainant or the applicant then have to enforce that order? What are the steps they could take?
All right, thank you for that. A very good question. Now, maintenance is a right. It is not a privilege. So it must be looked at as something that a person in a vulnerable situation, let's say a child, cannot be deprived of. Now, in the event that there is an order where maintenance has to be paid and it is not paid, the best way in which to enforce that is to go back to court and do a contempt of court order, as it were. So you're effectively saying to the judge, here's the order that you gave me. It said that he must pay me so much money. The reality of it is he's not paying me that amount of money, or he's not even giving me anything in that regard. Now, what then can the court do? Well, they've got a few options, but normally the most favored ones are having an attachment of the salary, as it were, in order for the parent to get that money. So how does that happen? The court may say, okay, Mr. Vilakazi, you are not paying salary. You are employed by XYZ employers. We will send an order telling your employer to put aside 5,000 Rand from your monthly salary and pay it to the mother of the child before you get your salary. So as an example, I get 10,000 a month, and the court says that 5,000 must go to her. My employer will pay the 5,000 directly to the mother, and I will get 10 minus 5, which is the other 5,000 that I have. There's also other options, of course, to the court. One of them is to confine, in other words, put into prison the offender. But that generally the courts have looked at and said, but this does not really help move the matter forward. The bottom line is there's a hungry child, so it doesn't help for us to take person and put them into a prison cell, because then they really cannot provide, and then they really cannot be earning a salary in which to provide. So the best way, attach one salary. The other way maybe to attach bank records as well, in order to assist in the process.
Thank you so much, Counsel. Is there any final remarks from anyone in the audience before Dr. Libeko starts to close the session? In the absence of further questions, I hand over to you, Dr. Libeko.
All right. Thank you very much, Dr. Lamont, and a very big thank you to Advocate Vilakazi for this detailed discussion. And I think I liked the nature of today's seminar, because it was really an interactive seminar, and I've really learned a lot. It's a topic that's slightly far from my line of practice, so I had to learn quite a few things here and there. I think I'll point out one or two things that really stood out for me in today's discussion. So before I do that, the discussion was mostly a two-part based discussion, where we're talking about gender-based violence, more starting from the home front, and then going to sexual harassment at the workplace. And one of the things that I picked up from the gender-based violence from the domestic one is the fact that you don't get the protection order from the police station, and you actually get it from the courts. It's something that is really eye-opening for a lot of us. And then also the fact that when we get to issues of sexual harassment at work, more so when there's issues of superiority or line management, there's channels that you can actually follow to be able to report that person without being jeopardized. And I think those are important aspects that really cripple our livelihoods in the South African setting, where because of such scenarios, people are not able to report their superiors in fear of losing their jobs. And the third thing that was really important for us today was the issue of being able to report the breadwinner and getting protection from such a person, and following legal processes to be able to protect you from not loss of income in the process of reporting the perpetrator as a victim, and also getting what I'd call proxies to actually assist in case of minors or in case of people that are not able to report such incidences. So I think today's talk was really broad but detailed at the same time, and picking some of the underlying issues that cripple, that hinder people from reporting such issues of gender-based violence and sexual harassment at workplaces, and even domestic violence at home. So these things have really been unpacked, and I think it's a very important seminar that we really need to put out there for the broader community to be able to take home, and to be able to know that there's channels that a person can follow in order to be protected from such acts of gender-based violence and sexual harassment. So on that note, thank you very much, Advocate Vilakazi, for this really intriguing talk, and thank you for such a detailed presentation of what could be done to protect us from perpetrators out there. Dr. Lamont, over to you.
Thank you so much to everyone for joining this evening, but a very big thank you to Council for actually being present tonight. I think he's enlightened us in several different areas, particularly around what are the exact steps that one can take. So never feel disempowered, even if your situation feels overwhelming at times. With that said, I would like to leave you with an African proverb. No matter how long the night, your dawn will break. Thank you, everybody. Have a wonderful evening. Bye for now.
Thank you.
Thank you. Bye.